Hello, Dan Marr here. I'm an attorney at Hamlin Kerrigan in Nashua, New Hampshire. I've been practicing for 35 years here in this firm, and I did a one-year clerkship when I started my career back in 1987 with the Superior Courts, learning the judicial system litigation, because I do litigation and transactional work. Today, this vlog, I'm going to be talking about what happens when two romantic partners who are not married own a real estate together. We've talked before in another vlog about how I would defend a case if one of the people are on a deed and the other former romantic partner is leaving and making a claim against the person that is the only one on the deed, how I would go about doing that, and I've dealt with that in another vlog. But here I'm going to be talking about you going into the relationship with your eyes wide open, and you're thinking about what's the options that we have. Perhaps you're in a situation where you were married before, you have children from another marriage, maybe there was a divorce, or you're widowed and you're now in a new relationship with somebody that you met or you've known for quite some time, and you both are going in with your eyes wide open. Whether you're in your 30s or you're octogenarians, you're in your 80s, it's good to go in with your eyes wide open to think about the relationship. I've talked about in the previous vlog that there is no common law marriage in New Hampshire. So you don't have, in this situation, common law marriage in New Hampshire is a limited statute where you are for 3 years living together consecutively. You're acknowledging each other as husband and wife. You have a reputation as husband and wife in the community, and one of you dies. So in this situation where you're talking about when one of you moves out and how you deal with the property, the common law statute doesn't apply, and you do not have common law marriage rights in New Hampshire. So you have to think about that ahead of time. So you might be in a situation where you're thinking about, okay, one of us is contributing more to the property than the other, and maybe we're putting a larger down payment, and you want to consider you both owning the property, but maybe it's a 60-40 split. And you can do that. You can put it in what's called tenants in common, which means under the deed itself, your portion when you die goes to whatever you state in your estate, and her or his portion goes in whatever they say in their estate. And we can talk, if you call us, I can talk about how that would be dealt with in trust. You can do revocable trust too for your respective interest in the property. But that's what you mean by tenants in common. And you can, and again, you can actually do it in splits, and you can say right in the deed. If you do that in a deed, and then later on there's a dispute, and you said actually 60-40 rather than just a normal 1/2, undivided half interest in the property, the judge, if there's a fight on this, what's called a partition action, may very well consider, okay, I want to hear the evidence as to how you came to that 60-40, and that might be controlling for the judge when they're looking at the whole issues. If there's an actual conscious thought process as to this rather than just the default of undivided half interest, because the judge doesn't have to just listen to that in the deed, it might be important. Contributions matter. The reasons why you bought the property, all of those things matter in a partition statute, which is basically a lawsuit in the Superior Court aimed at forcing the sale of the property. It's partitioning it, but the remedy is really they're forcing the sale of the property, and often what happens is after some litigation, one side buys out the other side in regards to the property. But that's when you have actual ownership. We talked about before what also would happen if you didn't have an interest and you had to prove first some equitable partnership interest, but we can deal with that later. Cohabitation agreements are another way to think about this. You could do joint tenants right survivorship. That means that upon your death it goes to the other person, and that might be the way you want to deal with it in your house. Sometimes people also have provided for their children from the previous marriage, but the house where they're living, they want to make sure their widowed spouse gets the house, and you can do that. You can talk to an estate planning attorney or our firm and deal with it. Cohabitation agreements, though, are going into, this is the way it happens if one of us moves out, it defines perhaps who moves out, how you can force the sale of the property, whether or not there is what the division of the property is. All of those things are put into the agreement, and very clearly I always put a provision in also that says there is no intent to do common law marriage, and this is only dealing with this piece of property and not providing for any support or anything else that's dealing with them. And I explained that all clearly, but that goes for prudent people that are thinking about what could happen. I've said before in contracts, good fences make good neighbors. Well, the same thing works here in a relationship, if you know what your respective rights are, you have a better situation, and you can probably work out differences later on when you have the rough and tumble issues sometimes with the relationship. So you can think that through, and that's important in the whole process, and that could also help with a healthy relationship. If you have questions, call me at 603-883-5501. That's Dan Marr at 603-883-5501. Or check out our website at hamker.com. That's hamker.com. Thank you.